Good evening, ladies and gentlemen, and welcome to the Residence Journal, national award-winning publication written by Chicago low-income residents. I'm your host for this evening, Mary C. Johns, and this evening we're going to talk about renters' rights, the rights of renters in the private market, of the housing in the private market, as well as public housing and Section 8 housing. What are the tenants' rights? And so we're going to be talking about this with our guest this evening, Rebecca. Hi, Rebecca. And could you tell me your last name?
MacDannald.
MacDannald. And she's the Hotline Supervisor for the Metropolitan Tenant Organization. So before we begin, I'd like to remind you to call the number on your screen, 312-738-1060, and call us and join us in our conversation this evening. And please be mindful to keep your comments and questions brief. And here we go, talking about renters' rights. What are renters' rights these days? A lot of people losing their homes to foreclosure. And so you hear a lot about the news and the president administration about how to help these people, these homeowners. But what about renters and low-income renters specifically, and these buildings that's becoming foreclosed? What about the renters in public housing and with Section 8 housing vouchers? What are their rights to keep them secure and a roof over their head? Okay, so could you explain a little bit first the background about the Metropolitan Tenant Organization? Who are you guys, and
what we do?
Yeah, what y'all do?
So the Metropolitan Tenants Organization, we have been around for 20 plus years. When we first started as an organization, we worked on passing the Residential Landlord Tenant Ordinance, which is what much of our hotline counseling now is based on. And so this ordinance was passed under Harold Washington, and it gives tenants a lot of, not necessarily more protections, but a lot of tools to hold their landlords accountable that they didn't have before. So not all tenants are covered under this ordinance. And I'll go into a little bit more about that in a minute. But what our organization does is we have a tenants' rights hotline. It's open from 1 to 5, Monday through Friday. Phone number is 773-292-4988. People can call in during that time, and counselors are available to answer their questions. Now, in addition to that, we have a lead program to prevent lead-based paint poisoning in the home. Lead-based paint poisoning is still very high in Chicago because we have such old housing stock. So we have specialists that go out and educate people on that, work with people to hold their landlords accountable. And we also organize. So if you've got a bad landlord and they're not responding to your letters, they're not responding to your calls, and it's, common issues that people have in the building, if it's about 20 units or more, sometimes a little less, we'll send organizers out there to hold those landlords accountable.
So you heard it here on Residence Journal, folks. You have some help within the Metropolitan Tenant Organization. Where's that office located at?
We have recently moved. I'm glad you asked. We now are located at 2150 South Canal Ports. We're on the second floor. It's just a block west of Halstead and Cermak.
Do y'all have a website?
Yep, www.tenants-rights.org.
Okay, so let's begin with our questions. Are there different rights for public housing residents and Section 8 tenants than there are for other low-income renters in the city of Chicago?
Absolutely not. Tenants who are on Section 8 vouchers or in HUD-subsidized buildings are covered under the same laws as other tenants. The only real difference, though, is in reality when it comes to using those tools that tenants covered under this ordinance have, it becomes a little different for Section 8 tenants and for HUD tenants. For example, tenants under this ordinance, if they have major repairs that need to be made, they can, go about the proper ways of writing a letter, 14-day notice, and they could possibly terminate their lease if the landlord fails to respond. The Section 8 voucher holders can't do that. They have to wait for the bureaucracy of Section 8 to get their moving papers. All tenants who do this have to be out within 30 days, and that's just not a reality for Section 8 tenants. For HUD tenants, they're not necessarily they don't necessarily have another place to go.
What is this ordinance you keep referring to? What's the name of it?
It's called the Chicago Residential Landlord Tenant Ordinance.
Where can a person find it?
They could go to the Department of Community Development under Housing, and it's the city publishes the ordinance, and they also publish a summary of the ordinance. And we also at our office mail out summaries of the ordinance. Now, one thing to keep in mind, though, is this ordinance only covers residents in Chicago. So if people are in the suburbs, it won't apply to them. In addition, if they're in a single room occupancy and they pay on less than a monthly basis, they won't be covered by this ordinance. And tenants in 6 buildings of 6 units or less whose landlord also lives there will not be covered. It's only if the landlord lives there and it's a small building. So
well, that's something, you know, the restrictions based
those,
on the building unit size and so forth, you know, seem to infringe on the residents' rights of that, you know, whoever they being exempt.
Yeah, those, that population, they still have rights, but they don't have the same sort of tools to use as tenants covered under the ordinance.
Could you give us an example of what you mean?
So, for example, a tool that, what I'm referring to, one of the tools that people may use is if, say they have a bad roach problem in their apartment. They could write their landlord a 14-day letter. They could, in this situation, maybe do one of 3 things: possibly terminate their lease if the landlord fails to respond in 14 days, reduce their rent for a reflected value of the unit if the landlord fails to respond in 14 days, or possibly repair and deduct for, now there are limitations on how much a tenant can spend for repair and deduct, but those are all options for people covered under this ordinance. Tenants who aren't covered under the ordinance, there's nothing in the law specifically giving them that right to just automatically do that. They may have to go through the courts. They should still put their concerns in writing. That's one of the most important things for any tenant, is to create paper trails, to have proof of things that are going on. But it just, you know, it's just a little different.
So if a person fitting the criteria for taking a landlord to court, but they don't have money and you know, information on who to go to, can they come to your organization?
Yeah, we have resources for those tenants. We have nonprofit resources as well that, you know, nonprofit attorneys that will help tenants who are low income.
Okay, another question is, for what purposes can tenants withhold their rent payments to the landlord?
So if there is a building code violation, the law specifically says for tenants covered under this ordinance, it's a building code violation, or if it's an agreement written to the lease. For example, if it's an appliance that's supposed to be covered under the lease, the procedures to do that so that it doesn't backfire on the tenant. Now, if a tenant does this wrong, it could backfire on them, and they could end up in eviction court. But to do this right, you write a 14-day letter. Give your landlord 14 days to fix the problem. If it's a heat or essential service, it's only 24 hours. They don't have to wait that long. So for basic problems, though, major problems like roaches, you know, bad plumbing, things like that, they can write a 14-day letter, keep a copy for yourself, send it certified mail to have proof that it was sent. If the landlord doesn't respond in 14 days, then they could reduce further rent. Only for the reflected value, though, and they could only move forward from that day. They can't go backwards in time. So, does that make sense? Yeah.
So, can they, like, say, like, the landlord neglected the roof for so long, that's now a hole in it, and it's raining in, and so it's an emergency situation, and maybe they failed to come when the tenants called for service.
Right.
And so now they, like, well, I'm not going to live like this. Is that a type of, for roof repairs, can they hold withhold rent?
In that situation, tenants call it our hotline about that. And, you know, what I always tell tenants is, you know, it's up, if I haven't seen it, I can't tell you, you know, but if a judge, it'd be up to a judge. So make sure you take pictures. It'd be up to a judge to decide whether or not this was a heat or essential service or just typical repair problem. But if you're, you know, if you've got water raining into your house, and that's probably a heat essential service. So give them a 24-hour notice.
Okay. For you